So a very good afternoon to everyone present here today. Myself, Samrat Sengupta, will be your host and moderator for today's session on impact of COVID-19 on construction contracts. Before starting the session, I would like to extend our gratitude and thanks to Lex Witness for granting this amazing platform during these trying times to bring us all across the legal and industrial sectors here today for sharing our views. We'll also like to thank PhD Chambers for their support to the endeavor. Everyone is aware that the world is today combating the coronavirus and its impact on worldwide economy. World Health Organization has already declared it as a pandemic. In India, the government has already invoked Disaster Management Act as well as the Epidemic Disease Act. As every sector of Indian economy is affected by this pandemic, consequently, the different contracts entering into these sectors are also affected. In today's session, our effort will be to look into the various aspects and the probable issues that one might come across during the performance of the construction contracts and the legal remedies that might be available. We shall try to discuss the impact of COVID-19 on the international as well as national construction contracts. We shall also try to assess the situation from perspective of industry. Now, let us introduce our panel of speakers. Now, giving for this thoughtful insight on discussions today, we have 6 very eminent speakers for you whose expertise in the field of law and construction industry are phenomenal. Our first speaker is Mr. Sourav Ghosh, Managing Partner of Jalan Company. The firm is one of the oldest firm in country having multi-locational presence. Jalan, who himself was a senior solicitor and a legendary figure in the Indian legal circle. Mr. Ghosh is a renowned advocate in the field of commercial dispute resolution, corporate transactions, corporate documentations, regulatory and disciplinary proceedings, etc. He has wide experience of acting for clients in various industries like infrastructure, real estate, banks, and NBFCs, amongst many. His practice also extends to commercial litigation, international arbitration, laws relating to foreign exchange acts, mergers, and acquisitions. Our next speaker of the day is Mr. Subhash Sethi, Chairman, SPML Infra. Mr. Sethi, with his vision and dedication, has been spearheading SPML Infra, and under his leadership, the company is presently a leading infrastructure development company with more than 2.5 decades of multidisciplinary experiences in water, power, environment, infrastructure, manufacturing, and technology. Mr. Sethi has also won the Economic Times Most Promising Business Leaders of Asia 2018. Our next speaker is Mr. Amir Singh Pasrich. He is the Chairman, Law and Justice Committee, PhD Chambers. Mr. Pasrich is a commercial lawyer with his expertise in various commercial disputes, arbitration laws. He has been deeply involved with international and cross-border work, having chaired the International Sales Committee of the International Bar Association, and presently a member of IBS Legal Practice Division Council. Our next speaker for the day is a person who needs no introduction in the legal field. He is a designated senior advocate and a renowned advocate in the fields of civil and corporate law. Let us welcome Mr. Abhrajit, senior advocate. Our next speaker of the day is Mr. Badrinath Dhruvsula, ex-VP and ex-General Counsel ACC. He has a wide expertise as an in-house counsel in merger and acquisition, transaction agreements, joint venture agreements, confidentiality and non-disclosure agreements, infrastructure projects in boot, deboot, and other models, structuring shareholders agreement, amongst many others. Our final speaker of the day is our very own Mr. Jaideep Gupta, senior advocate, Supreme Court of India, who needs doesn't need any introduction. Mr. Gupta's contribution to the legal fraternity is unparalleled. He is a barrister in law and a member of Honorable Society of Lincoln's Inn. He is also a member of governing body of the Supreme Court Middle Income Group Legal Aid Scheme. He is an instrumental factor in many landmark judgments before the Supreme Court of India as well as the High Court of Delhi. So, having said about the eminent panelists, now I would start with Mr. Ghosh, who will be the first speaker of this eminent panel. So I would like to give him a general overview of the COVID-19 situations in view of the various orders passed. Mr. Ghosh, my first question to you would be, please give us some general overview of the construction contracts. Over to you.
Yes. Good afternoon. Regards to my seniors and greetings to the eminent panelists and all the viewers. I thank PhD and Witness to ask me for this discussion. So we all know that Corona has touched every life in the world, and the life will not be same again. And there will be new set of rules which will come, and every sector has to modify their ways and practice. Construction industry, I will trace it back since civilization started settling down from being nomads. It started from building homes, then streets, then roads. And as civilization modernized, it built road networks, railways, then airways, airports, ports. Now we can see flyovers, tube rails, and again we find thermal power station, nuclear stations, and many more, shopping malls and townships, not to be forgotten also. Now we can divide construction contracts in two major parts. One is real estate contracts, one is infrastructure contracts. Now why this difference mainly is because real estate contracts, by virtue of Section 4 of the Transfer of Property Act and due to application of Registration Act and Stamp Act, stands in a different footing than infrastructure contracts, where infrastructure contracts is only governed by the realm of the Contract Act. Now, in real estate, we see there is a developer, there are landlords, and there is purchaser, lessee, lessor, and these all are interwoven through contracts. Obviously, there are subcontractors and laborers too. Well, in infrastructure sector, we find a principal who is an employer, then a contractor, subcontractor, and ultimately the laborers. These all parties are interwoven through different contracts and are guided by the laws as I discuss right now. Yes, to Mr. Samrat.
Yeah, so can you let us know the effect of this COVID-19 situation?
Any more questions, Samrat?
Yes. So can you let us know the effects of this COVID-19 situation on the construction contracts? Hello? 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 Am I audible?
Yeah, you're audible. It's fine.
You hear me?
Yes, we heard you.
Yes.
Mr. Ghosh, can you let us know the effect of this COVID-19 situation on the construction contracts?
Yes. I've heard you. I've heard the question. I think you're asking that effect of COVID-19 situation on the construction contracts, right? Again, as I said, the contracts are of two different nature. One is real estate, another is the contracts of infrastructure sector, and we are basically discussing about the executive contracts. And see, two very important factors will come into play today. One, as the government has already said, this closure of 2 months or another few months is a force majeure situation and is a act of God. Therefore, for infrastructure contracts, the doctrine of impossibility will come into play, which might lead to partial suspension or frustration of the contract, which is captured in Section 56 of the Contract Act. And if it is a partial suspension or a temporary suspension till the lockdown is over, then the question comes of extension of the contract. Although the government has said for 3 to 6 months extensions will be granted, but for completion of these contracts, further extensions I think is required. And there the time is an essence or not in the contract has to be reviewed. Now, there are contracts where there are specific stipulations where the time is made an essence. And if it is not, then extensions are granted on levy of liquidated damages. There we have to be very careful in addressing that if it is a force majeure situation, then whether liquidated damages should be levied or not. And we have to explore these things. For real estate, we have to, although the government has said there will be 6 months extension of the projects, but still the force majeure clause, which we have documented in every document will be of significance today, because post 6 months, the situation, what will be there and whether further extensions are required or not, has to be very significantly looked into. Yes, Samrat.
So what do you think? What difficulties the industry, the construction industry specifically, may face issues in this situation?
Oh, there will be difficulties which I think will be threefold, majorly to my view. One is labor, second is shortage of material, and third is liquidity. Labor, as we've seen, what is happening all around. Now, supposedly the work starts in any work site after 3 months. The contractors have to get the laborers and the workforce back. Now they've come at what rates is very important, and now there will be new set of rules of social distancing at the work site also to the workers. We have to provide sanitized places for lodging, for fooding, and many other rules definitely is coming our way, which will definitely increase the project cost. Second is the shortage of material. Now, we know that there is no manufacturing happening in last 2 months' time. It will not happen for another month or so. Whenever the work starts, there will be demand of materials, which will be lesser. And if the demand grows, the prices grow. And if the prices grow, it affects the liquidity of the contractor. Supply chain has to be rebooted. If there is a price variation clause in the contract, then we have to negotiate. If there is no price variation clause, then what happens? Then the project cost has to be increased. Those representations has to be made to the employer. Now, if the employer does not agree, what happens is there is invocation of bank guarantees. There is termination. There is blacklisting. And then the intervention of the court will start. I think all the parties to these contracts have to see the situation in a very reasonable manner and come to the table and redraft all the contracts once again. And we are also serving the interest of the bankers for these projects who have done lending. We are also paying EMIs to the equipment finances we have taken. And that also creates a big liquidity crunch for the developer or the contractor, whoever it is. Yes.
And lastly, I will want to ask you that you have discussed those problems, and can you tell us what are your suggestions to overcome such difficulties?
See, I definitely think there are other eminent panelists and other people all over India who have a lot of suggestions to come by. One or two I have thought, which I will share, is that firstly, at the right time, there should be representations to the employer that, extension of time should be given. There should be escalation also allowed. Now, the question is how much escalation and what time? No one can foresee today. So I think this is not a country issue, it is a global issue, because there is a lot of construction happening all over the world. So some matrix, some formula will come up very soon to, maybe it will be said a COVID-19 construction formula to ascertain tomorrow what is the escalated cost for these projects. What is the time which should be reasonably granted? Second, there should be definitely tax exemptions. For new projects, the workers' welfare cess should not be imposed. If there is a escalated project cost allowed, then no fresh BGs should be demanded. Moratorium should be granted for serving interest and paying EMIs for at least 1 year from the day the work starts. Monitoring committee for the state and the central contract should be created, where for next 1 year since the work starts, if there is any termination for non-performance, if there is any invocation, that should be cleared by that committee. And then only after review that actually there is a non-performance or not. Is there any real difficulty? Then only such notices should be issued. Second, no coercive measures until the committee sanction should be done. Any claim by the employer or developer should go to the committee, and the committee should resolve it within 1 month's time. These approaches should be made from the chambers and industrial houses and the associations to the state and the central ministry, agencies, PSU, whoever they are. Yes.
So taking on the cue, everyone needs to be very proactive during this situation, I suppose. So I will next invite Mr. Sethi to speak on. So to know about how the industry-wise perspective of industry-wise. So Mr. Sethi?
Yeah.
May I invite you? Yeah.
Yes.
So my question to you, sir, would be, how will the construction companies are going to cope up with the fixed cost components of a project? Like the payment of construction, including other facilities of at the project sites. And also in many cases, raw materials are stuck in transit due to the lockdown, and after the lockdown is over, there is a possibility in surge of the transportation cost of those raw materials, and additional expenditures like sanitation of the entire project, maintaining sufficient precautionary measures are going to be on your hands. So how do you plan to deal with that?
Thanks, Mr. Sengupta, and thank you everybody for attending the same. I think construction industry will go through a very tough phase now. This has never been faced by not only by construction industry, but by all industry. And this has to be dealt in a very proactive way. Every construction company will now face the problem of labor. They will face the problem of raw material. They will face the problem of organizing the COVID-19 protocols, everything they need to deal with. The fixed cost, I don't know whether the government will really look into from the perspective of whether they can give escalation, because everybody will come out with one set that this is not a part of your contract, and this you should have factored in all kind of these issues. We are dealing with the government, and whenever we ask for the escalation on any issue, we have never been paid. They come out with all sort of rules and regulations, terms and conditions, which are never workable, and then ultimately it goes to arbitration. My suggestion will be that one has to deal with this. They will have to bear with the cost, but they should keep writing to the government, to their clients, about all these extra costs which they are incurring. Do a proper documentation, do proper analysis of all the issues, so that that can come in handy at the time of settlement of the disputes. Number one. Number two, construction company has to now go through like we believe that there is a safety officer. Now there has to be a COVID-19 or COVID officer, where all the protocols has to be handled in a very, very proper manner, so that one instance of virus, if it impacted one, it does not impact everybody. So a proper protocol, proper standard operating procedure must be prepared before they start in the project. Third, the big issue which I believe that every construction where the work has stopped for last 2 months, there must be a lot of thefts, pilferages, which must have gone into here and there. The moment they start the project, they must do the complete inventory and find out what is the losses and other thing in pilferages, and they should lodge in FIR with the police and an insurance claim immediately. Because if you do not do the same day, then the insurance will not accept those claims, because then it is an afterthought claim. So the most important part is that they must do the complete inventory before they really start the work, and file FIR for all the pilferages and do the insurance claim. And I'm sure every project must be insured. Most of the projects are insured by virtue of contract condition. So my suggestion to all the construction companies and to the industry, that they have to bear with the cost, they have to bear with the escalation of the cement, steel prices, but they have to execute the project. They cannot get out the project, so they must keep proper documentations for all the escalations, so that the same can be fought at an appropriate time. Yeah.
So, in taking a cue from your whatever you have said, sir, what do you think that is there any from an employer standpoint? What are the changes that you are envisaging that the process of execution of the contracts will go on? If there is any good changes in the process, if there is because the change in process will ultimately may alter the terms of the contractual terms of the PA. So, what are you feeling on that?
I think this is the best time to reset the button of every company. This is the best time. God has given us this reset button on our lifestyle, on our professional handling, family handling, everything. I think this is the best. My suggestion that this is an eye opener for all of us. And we must agree that till the time a vaccine is found out, which can cure this disease, this is continue to happen till this vaccine is invented. We need to learn to remain with this for the time to come. We have to now reset the entire process. We must ensure that our entire workflow process is automated. We must ensure that our HR process, entire HR gamut has to be automated. We must also see that entire construction process is automated. This is the best time. In this time, every company should spend time in writing down the entire processes and do it automation. I can give you one example. If you can see the banks, State Bank or ICICI or other banks, with the 20% of staff, the entire operation is being done. Every bank is now fully, I don't think there is any lacuna in the banking operation. Operation part is being done by all the banks, all the transactions are happening just by sheer automation and with 20% of people. Now, why can't construction company also look into this aspect? They must have done their accounting process automation, but the entire now process, entire workflow process, it has to be now completely set to be automated so that this kind of event any time comes, we can do work without any interruption. We have learned now how to do the work from home. And this can only happen. Of course, we are also doing from home, but we're finding that there are a lot of still gaps, which we are now addressing how to write down all the processes, document, prepare SOP. So the best advice to all the companies, my suggestion, that instead of spending time on all other issues on day-to-day, fighting on the issues, first automate the process so that we can tackle this issue more effectively.
So taking a cue, I hope that the automation cost is really viable in today's projects, and then the labor issue, which automation there is always a fear that the automation may create a retrenchment. So leaving it there, sir, I will move on.
No, let me tell you now, there are a lot of softwares are available online, there are a lot of software which are available online, which does not cost much. What it needs a complete intervention from the top management so that they can start this. Now today, it's not that it's very expensive. There are online processes available on all the issues, be it HR, be it workflow, so on and so forth.
Yes, sir. Thank you for your views, sir.
Thank you.
I would like to invite Mr. Singh, Amir Z. Singh Pasrich. So P Chambers is a major trade and commerce motion of trade in service. Welcome, Mr. Pasrich.
Thank you. I didn't hear your question. I'm sorry. Could you repeat that?
Can you hear me?
Yeah, now I can hear you.
Yeah. So, what is your opinion on the impact of COVID-19 on delivery of justice?
Okay, thank you. Well, this is my 5th or 6th webinar on it since COVID began. And I have to say that in late March 2020, I had never heard of a software called Zoom, which we've suddenly started using every day. And I don't think many judges had either. We had a High Court judge, Justice Narula, on our first session, where we spoke about force majeure. And then we had 2 High Court judges, Justice V.K. Rao and Justice Rekha Palli, talk about employment law. And we learned as things were moving along, and I think the Delhi High Court and the Supreme Court have started moving in that direction tremendously
Yes.
towards video conferencing, which wasn't the case earlier. So suddenly COVID has opened up opportunities for us that were not even known to us. We never thought we could get 3,000 people onto a platform where we would go for conferences on the other side of the planet and speak to 40 people in person. Now you're speaking to 3,000 people thanks to this amazing thing called Zoom, or this amazing, whether it's video or Zoom or the various software. So I think that what we've learned from that and the justice delivery mechanism is going to be the possibility of virtual hearings, and they've already happened. I've done a couple, and I've done an arbitration, which has been tremendously cheaper than it would have been through the old process of 3 of my clients flying in from Germany, 1 arbitrator from Singapore, and 12 lawyers from different parts of the city all came together on one platform. So justice delivery has become suddenly oiled in a new way that only COVID could have taught us. It's jerked us out of a system of sluggish disbelief that there is something out there that we could use. And secondly, I believe very strongly that there is going to be a tremendous force and pressure on the legal system. So if all of you out there watching this, any lesson to take back, that lesson is try and avoid going to court, because the justice delivery mechanism of India is going to be under severe strain right now. Go to arbitration, go to whatever you can, resolve your differences by mediation or taking less and amicably. But if you go to court, the likelihood is that our justice delivery mechanism for the next few months is going to be very strained. And there's a huge backlog that's coming up, and that's going to cause difficulties for the system. If we are alive to it and we use virtual hearings and we start moving things faster and we're dynamic as a country, then there's a chance for justice to emerge.
Thank you for your views, sir. So, what do you think? Should the industry expect change in laws and regulatory protections for sustainability? I mean, as you said, the delivery of justice, what is your take on that? Do you need any change of laws or regulatory protections for sustainability?
Well, yes, I think there should be changes of law. The time has come for, well, firstly, I think that the laws around COVID themselves were hastily put together. The concept of telling employers to pay 100% salaries indefinitely makes no sense in the long term. You could have done it till the end of March, to the middle of April, but its continuation today is under a severe cloud. And the Supreme Court yesterday has issued notice on a petition challenging that. It is questionable whether it should continue for indefinitely while there's lockdown. But other than that, and I don't want to go into COVID legislation, post-COVID, what should happen is that virtual hearings will become better enabled if we have better rules for them. We need to have legislation for that. We need the government to step in and oil the judicial machinery with new laws that allow us to have, for example, hearings with fixed timings, costs actually apportioned, and the commercial justice system improved. We have a Commercial Courts Act, which is really not functioning.
So that's so then maybe what specific changes you want to know? Can you better give an insight on that? Maybe we have many aspects. There are many aspects. There are labor laws, there are employment laws, then there are these contractors, subcontractors, many issues. Can you give an example? You want a procedure that has been ever a challenge. So delivery of justice should be faster, the arbitration process should be faster, and how the PSD may go into a PSD may cater so can
Yeah, your sound was cutting out, but I think I've got the general sense of your question.
Mr.
If I don't answer it, then please correct me. I think I've understood your question,
So,
so I'm going to try and address it. If
please
I
carry
talk
on.
about it from the point of view of my chamber, and I represent the PhD Chamber of Commerce and Industry, and we have a Law and Justice Committee, which I'd urge all the lawyers to think of joining. We have, the chamber is representing a large number of MSMEs and large caps also. And I've noticed on the questions that have been put up by some of your attendees that they've got, serious problems arising, which chambers like the PhD chamber need to get together and address with the government, because you can't address them by going to court individually. You need to have some kind of solutions that work for large number of people. One of them, of course, is what do we do with so many employees? Whether there are two types of employees. One of your questions asked is someone who has, I think it was Dr. Gupta, who has 574 direct employees.
Yes, I saw that question.
Yeah, and over 5,000 people who are indirect. So what is going to be the scope of handling those people? I think you'll need a legislation at this stage from the government, which deals with some of these issues and also draws a fine balance. One of the things which has, I don't know where those 20,000 crores are going to go, but I think some of it should go into the actual pockets of people who have not been paid, people who are MSMEs and cannot pay, and this indirect system of routing money through them, whether it's 1.5% or 2.5% reduction in TDS. Today it was brought about, or these minor reductions in, for example, the Contract Labor Act. Yeah, I believe in one of the Gujarat or Rajasthan has revoked the 1982 notification, making the act inapplicable from 10 to 20 laborers. These are small band-aid fixes. We need a legislation which comes in and fixes things. And I think chambers like PHDCCI and many others will have to get together and tell the government that you need to have legislation on a wider scale. If you can't afford to pay us, you'd be surprised to know how today I've got an email from Canada is paying its MSMEs large lump sums in their bank accounts already received. And if we can't afford to do that, then we have to figure out a system to balance the weight of COVID between the employer and the employee, and other things also. For example, sorry to carry on too long, but I need to say this. Force majeure has often been misunderstood. Force majeure cannot apply for a lease deed. Let me make that clear for people who don't understand the law. I don't know where they're going to go with their cases and advice, and they think that it applies. Most of the time, you don't have a force majeure clause in a lease deed. But if you do have it, of course, you will be governed by its express provisions. Barring that circumstance, I think it's 108 subclause E of the Transfer Property Act, which says that, Transfer Property Act, it says that if your property is not destroyed or rendered inhabitable, you practically cannot go into suspension of rent. So please understand what that means for the industry, for those people who have taken rented premises, and also whether if they want to terminate, of course, they can terminate and walk out, depending on the terms of the lease. But they cannot carry on the lease in, say, September and say this small period in between, we're not going to pay, sue us. And then what happens when you go to court and it takes you 20 years to recover that money? So these are questions that are going to come up and are very hurtful and difficult to handle. And this is not change of law. Somebody's asked the question, is this change of law? No, this is not change of law. This is force majeure. This is very clearly and recognized as force majeure, and its impact has to be understood in context. Force majeure does not apply, and I repeat, does not apply to a payment obligation that has already accrued. So
thank you, sir. Thank you for your views.
Sorry for going on too long.
Thank you. No, I think questions are keep coming, and every one of us are enthusiastic. Even we are amazed by the fact that at the pre-webinar session, we already had more than 150 questions while people were registering and asking questions. So they must be very much enthusiastic about the topic. So moving on to the next speaker, Mr. Abhrajit Mitra, he is a senior counsel, as I told you. So, sir, the questions to you would be much more on a practical background, how you are going to handle the issues of bank guarantees and the payment of wages, those things. So my first question to you would be, what will be the effect on the bank guarantees due to the delay in execution of the project owing to the COVID-19 situation? Keeping in mind the fact that there has already been announcement by the finance minister that there will be release of bank guarantees in the government contracts to the tune of the executed contracts, and office memorandum has come out. But what happens to the rest of the pay? So after we resume our work, so I'd like to invite you to share your views on that.
Well, good afternoon, everyone, and thank you to the sponsors, PhD Chamber of Commerce, Jalan, and others. So far as bank, let me come straight to the point. So far as bank guarantees go, there is a circular office memorandum I have opened in front of me. In fact, this is of 13th of May 2020, which unfortunately I don't think will have any impact on disputed matters. The reason being, this circular only provides for return of the bank guarantees where the contractor has fully performed its obligations without a single default. And other situations is where the contract is performed. It's performed. But bank guarantee is generally not invoked in situations where there is a breach of the contract or the contract is fully performed. It is invoked where it is not invoked when there is no breach of the contract, when it is fully performed. It is invoked when there is a breach. And now there is bound to be breach of the contract because of the COVID-19 force majeure situation. Delay is, it's less, it is like judicial notice of the fact that contracts will be delayed. So the milestones will be broken. And this circular will have no impact on it. Then the principal, the employer will have every right to invoke the contract of bank guarantee and realize the money. And especially if you go by the strict bank guarantee laws,
yes,
the bank guarantees are being a separate independent contract. So even if there's a force majeure clause in the underlying contract that is between the employer and the contractor, it will have no impact. But fortunately for us, for judges and lawyers, we have a nebulous concept called special equity, which is imported into bank guarantee. And I find in virtually every case since the COVID-19 pandemic has broken down, every case there has been a bank guarantee injunction. My office has prepared, sorry, I don't think I can share any contents here, so I will not go into the pages. But there are cases of Delhi High Court, Bombay High Court, Rajasthan High Court, Allahabad High Court with a simpliciter given injunction. There have been cases where the special equity doctrine has been imported and said it's not possible for the contractor to perform. Let's be fair, we can't let the employer or principal invoke the bank guarantee because there has been default in performance. And almost invariably where the COVID situation applies, there has been bank guarantee injunction has been granted on invocation. But take my words, these are all interim orders. What will happen at the final hearing if the matter is argued at length is not known, but we expect the courts, the judges being human beings, we expect the courts to take into consideration the lockdown situation And only if the breach is dehouse the lockdown will the court refuse the injunction. Otherwise, bank guarantee givers, us, in my view, quite immune from any harassment by the principal. That's my view.
So, sir, yes, so sir, you are saying that we can even plead special equity after the lockdown period is over for the bank in case of bank guarantee is invoked. What do you think?
So for the delay period, for the non-performance,
for the delay period
and the consequences of it, like it will be a staggered lifting of lockdown, so you cannot immediately overnight go back into full performance.
Full force performance, yes.
There will be slowdown. There will. I mean, there are many consequences which are again coming within the doctrine of force majeure, as in escalation in costs. So the contractors will want increase in the pricing. There will be disputes on that. In some cases, the courts will respond to it, feeling that a contractor refusing to perform because the costs have doubled.
Almost.
Say for some industries, for some sectors, for some materials, costs have doubled. So there should be an equitable solution to it. But I can give you 12 judgments, orders have been passed in the last 1 month, courts granting injunction.
Sir, we'd like to email those to all the attendees there.
I will do it to you, and then you can make it available for them.
Make on that. So my next question would be, can you please share your views on the payment of wages to the employees and the applicability of the Payment of Wages Act during this COVID-19 situation?
Now, in fact, I only moved the Supreme Court yesterday for the Indian Jute Mills Association, challenging this 29th March 2020 government directive for payment of wages. This has nothing to do with the COVID, with the Payment of Wages Act. This is under the Disaster Management, Section 10(2)(L). The Supreme Court issued notice and also gave us a protection. No coercive measures will be taken against my clients. That means the jute industry, the jute mill owners. That's 2.5 lakh workers. Now, that again, Samrat, I must say, will not take away the employer's obligations under the Payment of Wages Act, under the Industrial Disputes Act, and more importantly, under the general law of contract. When the employee is willing to work and the employer is not laying off, is not declaring lockout. If he declares lockout, lays off, then 50% is the compensation payable. But if he doesn't declare lockout, if the employer doesn't lay off people, it's 100% obligation under the general laws of the land. Now, how it will be enforced? Because every employee will not be able to file a suit for recovery of the salary. Now, if they can bring it under Industrial Disputes Act or Payment of Wages Act, that has to be seen. That is untouched. I am not a pure labor lawyer, so I can't give you what are the available opportunities for the employees exactly under the different acts where to approach labor courts or industrial tribunal. But the DMA, this 29th March 2020 order, which was troubling the employers very much, that they've got some relief from Supreme Court. Now, what will be the final outcome, we do not know. Yes, Samrat?
Thank you. Yes, thank you, sir, for your views. Now we move on to Mr. Badrinath, please. Mr. Badrinath, can you hear me?
Yeah, very much.
Yeah. Sir, I would like your views on the in-house counsel. First, I would like to ask you that even if it is considered that the lockdown is removed in coming months, will the contractors or the subcontractors will be in a position to ensure immediately resume the project work, especially when the laborers in many projects have returned back to their home states? That is one. We all know that what is the issue of migrant works are being very much burnt and alive these days. So now, how is the industry planning to face that challenge? Also, how do you think the allied industries are going to be affected because of this lockdown? So this will be my first question to you.
Yeah. I think it's an excellent question. I think you gave a very sweeping statement about how the industry is going to look up. And I speak from the general counsel and the kind of an advisory which I give my company and the kind of a nuances which we undergo. But before that, let me thank PHD Chamber and particularly Mr. Amir Pasrich, Lex Witness, the seniors, Mr. Jaideep as Abhrajit and Jalan and company for being the co-panelists on this wonderful discussion. And there are about, I could say, a number of participants. I greet my greetings to them, to each of them. And I've also seen some questions which are already posted there. And they're all really interesting about the kind of the way in which the industry is going to look up in this COVID challenge. A couple of cobwebs I want to clear. This COVID is not going to go away in a matter of a 1 month or a 2 months or a 3 months. It's going to stay for at least a year before the vaccine comes, before the normality returns. And this is my guesstimate. It could be 6 months, it could be 1 year. So whatever we plan, we need to plan it in such a way that the contingencies have to be taken for a period of 1 year from the employer. Now, the second point which I would like to focus is that it's not that always the contractor or the kind of a firm which is really exposed to it. The government which gives the land, which gives the, in the case of an Indian contracts, it's a government is also equally exposed in terms of deliverables which it can give it, the free issue material. The project management consultants, they themselves are affected. The subcontractors are affected as well as the contractor. I am placing myself in the position of a contractor. Contractor, subcontractor, my principals, as well as my project management consultants, besides various suppliers. Everybody is impacted by this COVID situation. Now the question comes is that, how do you really address this issue? I place it in two contexts, one in Indian context, one in international context. Because I deal with both of them, it's very important to note, and I've seen from the questions also, how do you deal with them in an international perspective as well. If you look at it as standard domestic contract, it's always the standard form contract, and it is only one-sided. And many questions relate to the kind of a force majeure. Can it be treated as a force majeure? Can I really get the extensions or not? I think it's a very bigger question as such. The time will tell, and the legal luminaries on the panel, they've already answered yes and no to it. And we need to wait for the times to come, either in the form of a legislation, as Mr. Amir Pasrich is really pushing it through, or in the form of a code directive which would come, or the legislation which the government might enact. But be that as it may, I think there has to be some sanitation from the contractor's point of view. Today, what we singularly lack is in power of communicating to the principals. Once again, I reiterate, I'm speaking from a contractor standpoint of view. We need to communicate what are the kind of difficulties I have from the principals, what are the difficulties I have from the PMCs, my own supply mechanism, my own kind of the subcontractors, as well as my own issues related to the project performance. I think if all of them we need to tabulate and put it before the principal or the employer, obviously it would give some kind of a sight into how the problem is going to look like. It's not that they are not aware about it, but how well you document yourself and place it in the hands of your employer will really come to your success story. Now, why I'm referring to the international scenario is that internationally the contracts are mostly under the FIDIC kind of a contracts. In the FIDIC contracts, there is an appropriate coverage, though though it's not so explicit. But from my experience, I could say that the in-house mechanism of the employer is placed in such a is positioned so well that this kind of a situation can be relatively managed very well. So that be the case in Indian context, it becomes a very difficult situation. And in the international context, it becomes reasonably good. But how well you address it, it depends on your communication. So you asked me, Samrat, the question that how well you look at the kind of facing it or going forward in these issues. I don't think the labor will come overnight, or the kind of a consultants or the specialists whom I engaged for my project would come back in a matter of a 2 month or a 3 month, etc. So I have to keep a little longer schedule. So the first thing I would like to attack is, one is in terms of the communicating about my abilities or discomforts. Second is, I would place my reliance mostly on the schedule extensions, because this is something which is critical to the project management. And those who are into the project management, they would appreciate the schedule is a lifeline, and that is a key which I would like to tackle up.
Hello.
Yeah, Ms. Samrat.
Yeah. So thank you for your inputs on that. So moving on to the next question, from the company perspective, how do you think the infrastructure industry should plan in dealing with the contractual obligation vis-a-vis the government contracts and private contracts, and whether there is a room for modification in such existing contracts to safeguard the interest of the infrastructure company?
I think as I see how the things are going to have a thing is, like in the case of a green tribunals and the kind of an impact assessment study, I'm sure that the government would constitute a kind of an empowered group or a kind of a impact assessment group for each of the specific industries. Say, for example, for the buildings and construction or the infrastructure, roads and buildings, etc. The government is likely to come out with, and there have been representations made and some positive signals have come. So if that is the case, depending on the outcome, how the chambers will pull it out, or the kind of a government notifies, or the courts would direct, the impact assessment is going to have a tremendous bearing on the kind of a negotiating power. That's a first step. But that's not the be all and end all. That only gives a kind of a bandwidth, impact assessment. But beyond that, each of the contractors will have their own kind of a play in terms of the slips as well as the misses, etc., etc. So this is a situation we need to gear up with. And once the impact assessment is done, I have a room to negotiate. No doubt, I'm pretty confident that it will come under the force majeure kind of situation. Now, force majeure is fine, but can I have my waiver of liquidated damages? Can it cover my increased cost of working? And I have some of the equipment which need to be kept in O&M. So all these kind of a things which have to be there, these are all kind of a escalating costs which we have in the project management. So do I have the kind of a arbitrage when the notification comes as to what is the kind of an impact assessment that has come? So technically speaking, I would be prepared for a kind of, if it is a N that is given, that N plus kind of a 10 is a kind of a bandwidth which I will look at it. But yes, definitely it would give me a basic room to enter the negotiating table. How much of it I can squeeze depends on what issues I bring it to the table. But definitely the employees, be it India or be it abroad, they have been very sympathetic. Yes, no doubt they are strangulated by some of the rules and some of the notes Abhrajit just now shared. It is of no use, the office memorandum, etc. We faced all these things. But nonetheless, I think so long as this government is there in place, it will have some kind of a directive. It will give some kind of a directive to see that these problems are solved. Yes, we can negotiate the contract. We can negotiate on the value. We can negotiate on the timelines. We can renegotiate. I don't call it total innovation of the contract, but definitely there are certain key elements which we can negotiate, and there is an ample room for it. I am confident, and it is already displayed.
Thank you, sir. Thank you for your positivity. We understand. Sir, what would be your standpoint for the construction industry in dealing with the banks and other financial institutions as lending agencies during this period? Because everyone is going to be in a liquidity crunch these days, and they will be needing more money. So, what would the lending? What would be the approach towards your industry, towards these financial institutions, loans? How restructuring, making more payments to them? How to go about it?
I think Mr. Subhash Sethi also can supplement my thoughts. This is not the first time we are going to the lenders in terms of renegotiating our loans, etc.
I'd like to hear Mr. Sethi after you speak.
Yeah. That's where I just tried to rope in Mr. Sethi, because he's also struggling. I mean, I'm sure that he would be representing the same kind of the path which we are also having in terms of approaching the lenders, in terms of deferring their schedules. Forget about the COVID. Even the genuine payments which we ought to receive doesn't come on time. There are several conditions, several impositions, several restrictions which the government really imposes upon. So now the COVID is another situation which we need to grapple with, because it's already a kind of an enriched experience which we'll be going with the lenders. So again, when we ask for it, unfortunately, the government and RBI doesn't come to sync always in terms of payment to the payment mechanisms as such. Because The financial institutions have a different set of rules, and the government has got a different set of objectives. The sync between a RBI kind of a directive and the kind of a government directive are seldom at kind of a tandem. No, they are completely at variance as such. So obviously we have the difficulty, but nonetheless, we cannot go any other way except to go to the institution and to explain. But to go to the institution, to the financial institution, as I told you in the beginning, if I can compound my kind of an issues in a sequential data, what I am praying for from the client, and what is the kind of a cash flow schedule which I am now projecting based on the kind of an inputs which I have given to my client, I think they will probably plan it out in a better way for me from the financial institutions. But let me tell you, it's an uphill task for me. Unless until the government comes out very clearly on this directive as to what the ministry says is what the banks to follow, I think it's going to be a kind of an impossible task. The intent may be very good, but that content is going to be bad. Mr. Sethi, your views, please.
Sir, you need to unmute yourself.
Is it unmuted? Yeah.
Yeah. You can hear you.
Like, see, since the NCLT law has been deferred, I think it is the best that whoever the construction companies who are facing the liquidity crunch, they should approach bank with a proper justification of their repayment plan. And I think bank will now take a positive view. To me, it looks like now from the construction company's perspective, now they will definitely look into from the perspective that, okay, if the promoters are good, if the intent is good, if the past experience is good, the bank will definitely look into from restructuring the entire loan for a deferred period. But there is no direction. I don't think there is a direction. As Mr. Badrinath has said, there is no sync between what the government is intending and what the bank is intending. It's personality issues only, where one might accept, one might not accept. I think government needs to give a direction that all the concerned company or all the industry who is suffering, but there is a chance of reviving. Bank must look into from the position of reviving them, so that their money is safeguarded, the promoters are safeguarded, the industry is safeguarded.
So Samrat, I have just one point to add. That apart from being a contractor, we have a greater responsibility towards our subcontractors, because they are yet another species of kind of a institutions which are all dependent on us. It's a matter of a humanity, it's a matter of an institution, it's a matter of a support mechanism. So whatever problems I'm facing, I need to take the subcontractors along with it, because then only they will have a kind of a reposing the faith in my institution, and I'll be building upon my institution. So in all these problems, whatever I'm doing it, like in the case I have stated that I narrated all my examples about how I'm going to be placed. My subcontractor also need to place the facts before me. Then it will be a kind of a wonderful sync as to how much I'm speaking good about my own concern before a client. The client would also appreciate that there is a seamless kind of a representation, both from the subcontractors to the contractors, to the client, as well as to the financial institution. That will cut the ice, and that will put me in a good stead, both in the eyes of law, as well as before my client.
Thank you, sir. Thank you for your views. Now I'd like to move to Mr. Gupta, please. Sir, can you hear me?
Yes, of course. Can you hear me?
Yes, sir, I can hear. We all hear you.
Thank you.
Sir, I have come up with entirely a legal question that we have been bothering us. The effect, we all wants to hear that from you regarding the amendments of this new Specific Relief Act. Now, the amendment in Specific Relief Acts have been a significant impact on the infrastructure contracts. So, what are your views on that?
We are dealing with, first of all, my greetings to everybody on the panel and everybody who have tuned in to hear us on this seminar. I hesitate to use the word webinar. I dislike the word, and so I'll continue to call it a seminar conducted on the web. The issue here is, as you have heard so far, primarily in the realm of contracts, as far as the construction industry is concerned. And a few words to introduce before I come to the question of specific relief. We have to be very clear in our concepts here. There are thousands and thousands of contracts which are in the process of execution. Contracts, as defined in the Contract Act, are sets of reciprocal promises. I agree to do X, Y, Z. You agree to do 1, 2, 3. Now, you are going to apply force majeure, etc., etc. In order to do it, first of all, you have to identify what is the obligations you have taken out and whose obligation it is. We have to go step by step in analyzing this and applying the law to each one of these obligations. Now, I'll come back to the substance later, substance of the law later if necessary. But what is to be done if a dispute arises when you are in the process of executing a contract? A dispute arises because you are wanting to perform your side of the bargain, but the other side is refusing to take it. Or a dispute will arise if you are not able to perform your side of the obligation, but the other side is insisting on you doing it. Now, the traditional method of resolving commercial disputes was to give primacy to damages, and only where damages was considered to be not an appropriate way of solving a commercial dispute could we go to specific relief, which means a order, a direction by the court that you will perform a contract in a particular manner. Now, what has happened, and this is nothing to do with the COVID, but which will come in very useful, I think, in the current circumstances, is that in 2018, this Specific Relief Act was completely amended. And the primary purpose of this amendment was to change the approach from damages being the rule and specific performance being the exception to specific performance becoming the rule and damages becoming the exception. Because people felt that getting damages 20 years down the line after adjudication was no use. What was required was what to do with the contract at this present point of time. So with this in mind, two things have been done in the Specific Relief Act in 2018. Again, nothing to do with COVID, but very useful in the current situation and particularly relevant to the construction industry, because the construction contracts are the most complicated, some of the most complicated contracts that anybody has to deal with. Now, what they have done is to remove, as far as possible, the question of discretion in allowing specific relief, and they have also reduced the number of situations where discretion can be applied. There is an alternative mechanism which is called substituted performance. I have my doubts as to how useful that is. But the fact of the matter is that now it is not a discretionary remedy. It's by and large a remedy which ought to be granted if there is a contract in which has not been carried out. And the restricted conditions for which that it should not be compensatable by way of damages, etc., have been removed from the Act. Now, this has special relevance to construction contracts because there is a few sections which deal with infrastructure contracts. Infrastructure contracts are defined in the new Specific Relief Act to include certain sectors: transport sector, energy sector, water and sanitation, communications, and what they call social and commercial sector infrastructure. Now, this includes a lot. It includes hospitals, schools, etc., but it also includes affordable housing, which brings it pretty close to real estate contracts as well, and not just infrastructure contracts. Now, what it provides, and it may be of limited use, I understand. What it provides is, A, that there will be no injunctions in respect of infrastructure contracts. So therefore, you will not interfere unless it is necessary. That is not particularly important from the present point of view. But what is important from the present point of view is that there are special courts provided for in the statute to dispose of any proceedings arising out of the Specific Relief Act. And there is a procedure which says that it will be disposed of in 12 months with a maximum extension of 6 months. Of course, I understand that in an ongoing contract, even an 18-month period hiatus is capable of destroying the entire situation on the ground. So therefore, the point only that I wish to make is that the Specific Relief Act today is going to be the primary remedy as far as any contractual dispute is concerned. Samrat?
Yes, sir. Hello.
Yes.
Yes. Can you hear me, sir?
Yes,
Thank you. Yes. Thank you for your views, sir. What do you think are the future of the executory contracts in India?
Okay. Executory contracts, first for those of us who are not fully versed in the law of it, they are those contracts which on the day when the contract is entered into is not performed. It is something which has to be performed over a period of time. So if you are buying apples and you're paying for it then and there, it's not an executory contract. It has been executed at the very point in which the contract is being entered into. But if you are going to enter into a construction contract, which will be performed over a period of 18 months, then it is an executory contract. Now there are, as I said, thousands of such executory contracts in this country as of today. Now, I have already indicated that you have to identify the obligations. Now, we can't make any generalizations here. First of all, because the performance of contracts have been thrown into such confusion because of the change in environment that we do not really know what we are fighting. Because are we fighting a 2-month delay? Are we fighting a 2-year delay? We really don't know what is the scope. So all that we can do is to keep in mind some very basic principles, which I'd like to indicate. The first principle is that there are two kinds of situations. One is if the obligations are dealt with fully in the contract itself. And the other is if it is not dealt with fully in the contract itself. Now, what do I mean by dealt with? You see, an obligation may have a time frame. It will have a person who will do it. It will have a time frame. Now, if the contract provides what is the time frame and who is to perform it, and if the time frame is delayed because of COVID-19, in that event, it is first of all, we have to look at the contract to find out whether it says anything about such a thing. It does. Many construction contracts say that if there is a delay envisaged, then, and if you are going to claim either escalation or you will claim extension of time, etc., then many contracts provide clauses which say that you will have to give a notice to the employer straight away, saying that these are the reasons why I will not be able to perform this contract within the period that is mentioned there. I will require extension, I will require escalation, etc., etc. Now, if there are such contractual clauses, then one has to follow that, of course. If there isn't such a contractual clause, then we'll have to look at the law to see how to deal with that situation. And when we are looking at the law, we can look at it in this fashion. If it is not fixed, if let us say the order of performance is not fixed, then we go to the Contract Act and find that it will be fixed as per the nature of the transaction. Similarly, if the time limits are not fixed, it is said that it will have to be performed in a reasonable time. Now, this word reasonable time is very useful in this context because the reasonability of the time is going to change depending upon the COVID circumstances. So COVID will change what is considered to be a reasonable time frame for performing obligations under a contract. And if there is no absolute deadline under the contract, then it will be open to you to argue that the reasonable time in which a particular obligation is to be performed is more than what would be reasonable in a normal situation. Now, therefore, just coming back to the first point, that if it is provided for in the contract, it's a matter of interpretation. Now, there are many contracts which provide force majeure conditions. Most of these force majeure conditions will not be of any use to you. Why? Because those force majeure conditions will say under what conditions the contract will come to an end. We are more interested in those situations where particular obligations under the contract have been affected by the COVID conditions. Therefore, we now fall back on the general law on this. There also, you're not going to get too much assistance, because the law of frustration, which is contained in section 56 of the Contract Act, is a very, very narrow rule. The leading authority on it now is the Energy Watchdog case, which says, and if I tell you what it says, it becomes clear to you why it's not going to be of much use. And it is a lot of it will be up to negotiations, etc., etc. First of all, the law appears to be that it may be impractical and useless from the point of view of the object and purpose of the party. It does not have to be literally impossible. But this is not to be casually arrived at. It's not to be lightly applied. It is not merely because it becomes more onerous, and a mere rise of prices of raw materials would not make it an impossibility within the meaning of section 56. So therefore, what is going to happen is that the general law of frustration also, as it stands today, is not going to be that useful to us, which is why looking at it from a lawyer's angle, I think dispute resolution mechanisms which we have today are going to be challenged in the process, and we will have to either have new dispute resolution mechanisms, or we'll have to have new rules by which contracts can be regulated. Now, the normal principle, and this is the last point that I wish to make, the normal principle is that a court never interferes with the contractual provisions. However, there is a whole area now of regulatory law, what I call regulatory law, telecom, energy, gas, electricity, etc., where you use an amalgam of contract law and administrative law to arrive at a situation where the regulator is in a position to make changes to contracts which have been negotiated between parties, and to say that this clause can work out, this clause cannot work out. So we have such a situation in existence, administered through tribunals with appeals to various courts. So it is quite possible, and I think that that's a very likely situation, that there will be new laws to cover the COVID situation, and that there will be new tribunals having regulatory powers to even alter contracts if necessary in the process of resolution of whatever genuine difficulties are going to arise because of the COVID circumstances. So, Samrat, anything that you...
Yes, sir. Sir, you have mostly covered those. I was about to ask you any suggestive legal measures for the government to come up with certain notification, etc., as a measure of clarification for determining the effect of COVID-19 in case of government as well as private contracts. Because as we have seen, the office memorandum, which refers to the procurement manual that came sometime in the March, speaks about the government contracts only. So we don't have a mechanism right now or any circular coming out from government for regulating the private contracts. So what is the suggestion on that?
In my view, private contracts will require legislation, because even if the government was to issue guidelines, etc., the question is one of law. The courts are not bound by the government's interpretation of the law of contract or of any particular contract. So if you do not agree with the government's interpretation of it, then you'll go to court and you'll have to wait for an adjudication on it. Which is why I'm wondering whether a special legislation which sets out new rights and obligations and which permits a regulatory authority or a tribunal to adjust equities and bring about new solutions, whether that can be a way forward or not.
Thank you, sir. Thank
Mr.
you for
Samrat, just an alert for you. We have extended the webinar time by 15 minutes because of the attendees' request, as there are a lot of questions.
Yes, there are a lot of questions that are coming on. So a few can be taken up at this point of time. So thank you. Mr. Badrinath, there are a couple of questions on the design and drawing and the consultancy and engineering default. So can you enlighten us on that? Mr. Badrinath, you need to unmute yourself. You need to unmute yourself. We can't hear you.
Yeah, is it okay now? Yeah.
Yeah, it is okay now. Thank you.
Fine. Thank you very much for these lovely questions, because both of them are very relevant. One is that one set of questions I have seen in the webinar is that whether the consultant's contract can be the kind of a subject to the COVID mechanism extension part of it. Second is whether there are any designs and drawing kind of an approvals which have been delayed because of COVID situation, whether it would be covered under the kind of an extension mechanism. As I was telling you in my very first question, when how we approach the client, let's respect the clients, because the employers are somebody who have been, we have to live with the employers have to live with the contractors. The world is going to be the same. We are the set of some 100 contractors, and we are going to have the principle of some 20 principles. So this relationship management is very essential from a company point of view, whether it regulates individual layers like the consultant's contracts or that of the design drawing delays as such. Why I'm speaking about the relationship is that this is what some of the companies are very well established with the kind of a government agencies as well as the non-government private participants. So this is very essential. Yes, both the things can be covered. One is the design and drawing. Let me come to the first leg. That is something which comes as a matter of a schedule under the normal mechanism when the contract is finalized. Obviously, when the impact happens on the design drawing completion part of it, there'll be kind of a contributory concussion kind of an extensions of schedules, which will happen in the subsequent leg. So once the first leg is impacted, the design and drawing leg is impacted, it will have a lot of connotation on the kind of a material procurement or the construction part of it, which will come in a subsequent schedule as such. So this is something which need to be addressed and which will be considered. And this is something of a very fair and simple play, as I could see it, either from a notification or other perspective. But coming to the second part, that is the consultant's contractual extension part of it, that is a little bit of a dicey thing, because the consultant's contracts are something which are very specific to a particular job. But nonetheless, I don't rule out the possibility that there could be an extension, but it depends on what type of consultancy it is about. If it is something related to the core of the kind of a scheduling or the kind of a performance or anything as such, certainly the client would consider. But if it is not coming into the kind of a core activities, probably there is a contest we may have to undergo as such. There is no simple plain vanilla answer to it, but nonetheless, both the things can be covered. The first one with a robust mechanism about the design drawing delays, and about the consultants, it's a question of a touch and go, how sensitive it is to the contract.
Thank you, sir, for your views.
Mr. Samrat,
Mr. Ghosh, can I invite you with a question?
Mr. Samrat,
you have a live, okay.
Question.
So we'll take that.
Please
we have a
allow me
live
to
question.
take a
We'll take that question. Yes. This question is for?
Mr. Mrityunjay Roy, can you please go ahead and ask your question?
Please.
Mr. Mrityunjay Roy, please go ahead and ask your question, sir.
Hello, am I audible?
Yes,
you are audible,
sir.
Mr. Roy, you are audible. Please go ahead.
Yeah. The question which I wanted to ask is, day before yesterday, the finance minister stated something about the bank guarantees, and accordingly a notification has been published. Now in the notification we find that it is only about the performance bank guarantee and not about the retention. My question to the forum would be that will it only be limited to the performance bank guarantee, or it will cover the retention also?
I would like Mr. Mitra to answer this one. Mr. Mitra, can you please illustrate on this one?
Advance bank guarantee is always returned after the advance which the contractor is paid is adjusted against the bills. So if the bills are raised and the advance bank and the advance amount adjusted, the advance bank guarantee is returned. This circular, if I'm not, does not specifically talk about return of the advance bank guarantees, but that's the general law will apply. So if the contract is allowed to be performed, maybe beyond time because of the COVID-19 pandemic, once the contract is performed and the bank guarantee amount fully adjusted, and the advance fully adjusted from the bills, the advance bank guarantee will be returned. Advance bank guarantee technically does not have so much to do with the performance of the contract as it has to do with the adjustment of the advance received by the contractor from the employer. Of course, one is linked with the other, but it's primarily for realization of the advance.
Thank you, Mr. Mitra. Subhamay Chakravarti, please ask your question. Subhamay Chakravarti.
Hello.
Yes, please go ahead.
Can you hear me?
Yes, please go ahead, sir.
My question is that in the MSME Act, there is a provision of statutory interest. So if due to this COVID-19 condition, if the statutory interest part is not complied with, then what will be the consequences?
So you want to know about the statutory interest part?
Statutory interest, but it is legally payable to the contractors. It is a statutory legalized portion of the MSME Act. But due to this force majeure reason or due to this COVID-19 reason, if it is not paid in time, then how the force majeure reasons clause can be invoked, how the statutory part can be looked into this matter.
I invite Mr. Ghosh to answer this one. Mr. Ghosh, I'm audible to you. Hello. Mr. Ghosh, am I audible to you?
Mr. Ghosh is not online right now, sir.
Mr.
Can
Ghosh
somebody
is not
else
online.
address the question?
Then Mr. Singh, can you come up with an answer to this? Mr. Singh, unmute yourself. Yeah. You need to unmute yourself. Yeah, okay. Thank you.
Yes, I think the answer is quite simple. For all statutory liabilities, the liability accrues by something which has nothing to do with force majeure. So the same applies to you vis-a-vis statutory interest as you would pay under a contract. There is no interference with that. Time passes, interest is due. I think you would be hard pressed to claim any kind of force majeure, but maybe if the government comes up with a special notification to suspend it, you can apply to the government, and they may. These are the small SOPs that they are giving to MSMEs. And as I said, a chamber like the PhD chamber can certainly apply and say this is affecting a large number of people. Then you might get a relaxation. But legally, I'm afraid I don't think that you'd get a relaxation in law simply because COVID is taken place. I don't know, maybe Jaideep, if you can nod in, if you agree with me, because I don't think there's any, I'm sorry, I sound very tough when I say this, but that's the way the law is. So that's it.
Thank you, Mr. Singh. Ms. Savita Sinha, can you please unmute yourself and ask your question live? Ms. Savita Sinha.
Yes, good evening, sir. My question is to Mr. Abhrajit Mitra. He talked about situations which will devour the lockdown in case of bank guarantees. Can you give some examples of such situations which divorce the lockdown?
I will tell you.
Yes, sir.
A contract, a works contract for 10 crores. is entered into. The principal gives a 1 crore rupees advance to the contractor at the beginning, which is to be realized by adjusting 10% from each bill, work for each running account bill, for each bill, from each bill. Now, how does the employer ensure that the contractor won't run away with the 1 crore without doing the work? The contractor gives the 1 crore corresponding bank guarantee. So as and when the 1 crore advance which he has received is adjusted from the bills for the works he has done, he will get back his 1 crore advance bank guarantee.
Okay.
So I would like to I'd like to read out one question that has come to my notice during this session. This will be to Jaideep, sir. So can you hear me now?
Yes.
So I'll read it out. Now, Section 10 of NDMA provides that the center can issue guidelines to state to implement the national disaster plan. Now, absent a national disaster plan having been prepared under Section 11 of NDMA, what is the legal validity of the guidelines being issued under Section 10 by way of the various MHA circular?
First of all, there is a national disaster management plan in place.
Yes.
It is already there. It is a very sketchy plan, but it has 2 pages of it are devoted to biological disasters which may arise because of biological reasons. And it does therefore include conceptually a COVID crisis. Now, these 2 pages are so cryptic that you would not be able to actually give any effect to it. I mean, you cannot deal with situations on the ground based merely upon the plan. But that is why the provision is also there in the Disaster Management Act for issuing guidelines, which is the avenue that the government has taken in the present case. Now, the power to issue guidelines is there both for the central government, the National Disaster Management Authority, as well as state disaster management authorities. Of course, we haven't seen too many guidelines issued by any state authority. We have seen guidelines issued by the national authority. First of all, it does not require a national disaster management plan to issue guidelines. The provisions of the sections of the Act itself are sufficient to allow the authorities to issue guidelines. These guidelines have the force of law and they can be enforced in accordance with not only civil law, but also criminal law. Certain provisions are in the schedule to the Act itself. So these guidelines are certainly a way of going about it. You might say that guidelines without any overall detailed plan may be slightly hitting in the dark, but I guess it is making a new disaster management plan would be very difficult under the present circumstances.
Okay. Thank you.
Samrat sir, we have a live question. Can we take a live question?
Yes, I presume there are a lot of live questions that are coming in. So, Akshay, you can take those questions.
Cajetan Fernandez, please ask a question.
Okay.
Yeah, my question is regarding the escalation. Now, supposing in the contract, first question is like, should we consider the escalation and for what? I think this question was explained by Mr. Badrinath that we should consider the contractor to raise the escalations. But is the escalation for the idle time, idle labor, the rationing given to them, the salaries given during the COVID time, or is it for the time lost? And second thing, in the procurement of the material, the escalation should be considered or not if there is no impact on the material, or if there is a rate contract or the basic rate given to the materials wherein all the escalation is paid or minused.
Okay.
Mr. Badrinath, you would like to answer that?
Yeah. Can I go ahead with the first set of questions? The first one you asked about the increased cost of working. Let me put it under the bracket of increased cost of working. Say, for example, for the kind of a project management, you have a labor colony, and the labor colony, you have about 100 laborers or maybe some 10 supervisors, etc. And there is a cost associated with it. And you projected for about, let's say, 12-month kind of a period. Now it's going to be 15-month period. This tantamounts a kind of a increased cost of working. There will be a regular provision in the part of the contract which takes care of such contingency, not necessarily split into the kind of a laborer's food, wage, their dress, their travel, etc., etc. But the kind of a generic clause will be there. Under that clause, and the kind of a weekly review meeting or a monthly review meeting, this is something which we can put up, which is saleable, which definitely sails through. That is the first part of it. So obviously you need to have the kind of a correspondence backed up by proper documentation, which need to be placed in the hands of the client to ensure that this is considered in the best possible manner, and your chances of success are almost about 70 to 30. Now let us come to the second part, is in terms of material. Material escalation, maybe with the efflux of time, or maybe with the kind of a pandemic, or etc. I think that is a little difficult thing to really sail through. It has got two splits in it. One is fixed rate contract, second is a variable rate contract. Even then, the bandwidth will always be already provided for, and it is unless and until you showcase that it is a very critical sensitive equipment which has to come at any cost, without which the rest of the equipment will not be aligned to the kind of a project functioning, is something which you can demonstrate. That particular equipment or that particular piece will be considered for the price escalation. It's not a generic price escalation for everything and anything as such. Say, for example, there are some critical compressors which are there, or some critical equipment which need to be erected, or some kind of a earthwork need to be done. That will be considered, but not everything per se.
Thank you.
Thank you. So move on to the next question, Akshay.
Mr. Rajita Ghosh, please ask your question live.
Hello, everyone. Thank you, Mr. Sengupta, for giving me the opportunity to speak before this wonderful forum. I have two questions. One is where there is no time specified in a construction contract, then in that case, what will be the reasonable time the court will consider, or what will be the calculation that the court will come up so far as the reasonable time is concerned in the construction contract, since we are only discussing about construction contract? Number one, this is my question. And the second question is, Jaideep sir was discussing about Section 56 of Contract Act also, which states about the frustration of contract. So I was attending one day Dr. Manu Singhvi's webinar, where Dr. Singhvi was saying that for the frustration of contract, that the nature should be permanent or semi-permanent in nature. So now in this situation, the lockdown has extended. So this is the third phase about to end. The fourth phase is about to start. So what will be the effect that whether if it continues, even if the lockdown 4 starts with certain conditions, the pattern of working won't be the same. So in that situation, will that be construed as semi-permanence so far as Section 56 is concerned?
First part of the question, thank you, Aradhita, for asking these questions. First part of the question, can Mr. Ghosh take you? Hello, Mr. Ghosh, are you online?
Me?
Yes. Yes. So can you take this up, the first part of the question? The second
What
part
was the question? What was the question?
Yes, I was asking that where there is no time specified. Hello, am I audible?
Okay, I remember it. See, we have to see, as when I was speaking, I said in construction contracts, either you have a critical clause which says that time is essence of this contract. If there is no time fix, then as Jaideep sir said, it is a reasonable time to be construed. Now, when you apply for an extension, you have to see that what stage of contract it is. It is 50% done, 90% done, 10% done. Accordingly, the extension has to be asked. There, the question what we were discussing again and again, the negotiation part comes in. Now I am asking for 2 years extension, but the employer is giving me 1 year extension. I have to see that whether I can complete in 1 year's time, or I have to abandon it because of the impossibility factor, where if the object is destroyed, I cannot perform the contract. It gets frustrated. Okay.
So now second part of the question, sir, Jyoti sir, can you illustrate on that?
Yes. You see, frustration, section 56 makes a contract void. That is to say, the entire contract will collapse at that point of time. Both parties will be released from their obligations to make any further performance of the contract. So naturally, we are talking about a situation where the contract is coming to an end. That is perhaps why Dr. Singh would have used the word permanent or semi-permanent. What he perhaps meant to distinguish this situation from is a temporary delay in the execution of a contract, which does not put an end to the obligations of the parties, but which justifies the extension of time. This is the reason why in the very beginning I said that we have to be very careful to identify what are the obligations, 1, 2, 3, 4, 5, whose obligation it is, and what are the time frames for each of these obligations. To take a construction contract, as you know, there are multiple obligations. The obligation to deliver site, the obligation to give drawings. These are usually the kind of obligations which the employer takes. Then the obligation of the contractor to mobilize, the obligation of the contractor to give guarantees, etc., etc. The obligation of the contractor to finish, say, 20% of the job within a particular time limit. So each one of these are obligations. They have a particular person who is supposed to do it, and they have a question of how much progress is to be made. This is not a situation of complete frustration of the contract. If each one of these are impacted, then it is not true that the whole contract is incapable of performance. For instance, if a construction contract is required to be set back by 3 months, it will improve, it may increase the cost, etc., etc., but it will not make it fundamentally impossible. But suppose a construction contract is delayed by 10 years, then yes, it might be that the purpose of this contract will have failed. So I think that's the meaning of permanent and semi-permanent in the framework of section 56. 56 is a very drastic remedy. It puts an end to the contract altogether. It will come into effect only if the parties believe that they cannot go ahead with the contract at all.
Thank you, Mr. Gupta. Mr. Adarsh Kumar, please ask your question live. Mr. Adarsh Kumar, please ask your question live.
He's on mute. Adarsh Kumar need to unmute.
Am I audible? Hello?
Yes. Yes.
Am I audible?
Yes, please go ahead.
Yes.
Sir, my question is related to Mr. Badrinath, or any legal person can answer this question. My particular question is related to the notice of the force majeure, sir. As per the FIDIC contracts, there is a notification days, like 14 days from the start of the event. Any notice of the force majeure should be made after 14 days from the start of the event, and notice of the claim to be made within 28 days after the affected party become aware of the event. So here my question is that even because of this is a force majeure, and even that some contractor has not given notify their employer properly within the stipulated time frame, then what would be the consequences? Whether their claim would be denied, or will it be sustained?
Can I answer this question?
You can answer this, or Mr. Singh can take over whatever you like.
Samrat, I'll just first answer from a practical perspective, then probably from a legal perspective, another can answer.
Yes.
First of all, your conception that it is a force majeure is not valid. You have been already attributing it as a force majeure, which is not clear at this point of time. So, but you construed for yourself that it's a force majeure. So obviously take the advantage and the first mover advantage. You have to notify whether it is a force majeure or not, because it's already, the dates are known, the world knows about it. So please go ahead and go ahead with the kind of a force majeure situation. Then it is a question of a 14 days or a 7 days, that doesn't matter. or 28 days from the time you come to, or whether the claims will be entertained or not entertained. It's a question of a long gestation kind of a phase it's going to take. It'll at least 6 months before you receive your first tranche of some kind of a consideration the employer is willing to give. So please go ahead and give the notice and never treat that the force majeure event has already occurred. But for you, it has occurred. It has not been accepted by the client as yet.
I think this is all answered very, very aptly. Nothing much more is required to be on that. So can we move on to the next question, please?
I just want to say,
Gupta
just want to say one
Yes.
thing.
Yeah, yeah, Mr. Singh, please
Just
carry on.
the short addition to that, and I completely agree with Badri, Mr. Badrinath, Dhruvsula. I would just add that when there's a force majeure clause in a contract, it is strictly construed. If there is provision for you to give notice and you didn't give it on the 23rd of March, then you've lost all that time. You should have given it on that day, in fact. So if you invoke it late and the terms of the contract are against you, then you might suffer the consequences of not giving the notice. That's all.
So you are saying that contractual terms are going to govern that?
Yeah, if you see, a force majeure clause can't be taken outside of
the contract.
It's an ecosystem of its own kind. And although there are provisions of the Contract Act, like Section 56 about impossibility, which you can invoke, but you can't take, it's not a path where you can go under force majeure of the contract on the one hand and impossibility on the other. So you have to choose. If you choose to go under the force majeure provisions of the contract, then you have to read those provisions and abide by them. If it requires a force majeure notice to invoke the clause, it says normally within 48 hours or within so many days, you will notify the other party. So every day that you lost in between and didn't send that notice, I think you have to and
justify those.
Yeah,
yes.
You have to justify. Otherwise, they will take the defense that force majeure came into existence when you invoked it, at least, and that will delay your benefit. That's what I wanted to say.
Can I just add something? First of all, under Section 56, notice is not a requirement. It has been held by the Supreme Court that if the conditions of frustration are there, then whether or not a notice has been given, the contract can be rendered void, number one. Number two is that there is Delhi High Court authority that if the condition says that you will give notice within a particular time, this is an Indian Oil case. Indian Oil contracts all contain that clause of 14 days or whatever. If you haven't given that notice, they have specifically said that you will not be entitled to get the benefit of the force majeure clause. So this is something which is already.
So that's a complete bar there.
Decided.
That's a complete bar.
So Jaideep, one question arises, and what happens if you have an alternative plea taken? If you take the plea on the one hand, I want to invoke the force majeure, and you didn't, like this gentleman did not invoke it in time, and then you invoke impossibility, you can take, I mean, as I see it, the benefit of both those judgments. In this particular case, I would advise you to try both alternative pleas, and you might succeed in one, if not the other.
The only thing I would say is that if the same facts are relevant for the force majeure clause in the contract as well as for Section 56, the court may decide that the parties had by express agreement included a requirement of notice. But it's a very interesting case, point that you raise, Amir, because if the contract is rendered void by an operation of law, then whether there is notice or not should not matter. It will have to be adjudicated.
Thank you, Mr. Gupta. Mr. Govardhan Gaddam, please ask your question live.
Yeah, good evening. I have 3 questions. First 2 questions I would like to talk to Mr. Mitra ji, and the last one is with Mr. Badrinath. See, you said mobilization advance. I'm not talking on the mobilization advance. Apart from mobilization advance, in the project, we supposed to give a performance bank guarantees and security deposits in the form of bank guarantees, FDRs, that is also in the form of BG, something like. So is it applicable, the clause, the partial reduction is applicable for all these bank guarantees other than the mobilization advance? That is number one question. Second is that this partial reduction is also applicable to the O&M works, because O&M is not, it is a project. It is a program, one kind of program. It's not a project. So is it also applicable to the O&M projects?
What project could you just repeat? What project?
O&M, sir.
Operation and maintenance.
O&M, operation management.
Operation and management.
Operation management. Yes. Fixed deposits are also form of security.
Yes.
So if fixed deposits are given in lieu of bank guarantee, it will also be returned to you once that obligation is discharged. See, instead, for the advance which you've received, if you give a fixed deposit, or for performance, you give a fixed deposit instead of a bank guarantee. Instead of forfeiting the fixed deposit, the employer will return it to you if you perform the obligations. The only difference which happens as per this circular or the office memorandum is that it provides that, I'll read out to you, the contractee, that is the government department agency, may return the value of the performance security, whatever form it may be, bank guarantee, maybe fixed deposit, to the contractor as is proportional to the supplies made / contract work completed to the total contract value. So that the contractor may say O&M contract also, I have performed 50% of it. There is no chance of that reverting back to me.
Okay.
So return me the 50% of the performance security I've given to you.
Okay. Thank you very much. And my last question. See, across the globe, the industry is not, gone into the production level, and supply demand is reduced, and drastically it is affected on the across the industry, I can say. At the same time, if you look at the crude price, it is also come down drastically, almost near to the zero. So this is a drastically impacted on the price indices, and this leads to the price escalation. It's all, when you look at the price escalation, it's all negative side. So in the contract, we have a clause for the price variation. So whether this COVID-19 situation can be taken advantage to not to apply this clause, negative clause for this price escalation?
No, I don't. No, I don't think so. No, it is not possible, because the price variation is something which is as per the terms of the contract. Whether it is, because it's both on the plus as well as the minus side. If you read the clause properly, it will speak about the positive as well as the negative part of it. So if it drops down drastically due to COVID situation or any other situation, the clause stands on its own legs in terms of negotiation, and we cannot escape from that. That is a kind of a reality we need to face. And on the first question about the O&M, I'll just supplement, sir. Abhrajit sir, I'll just supplement what you have said, that usually what happens is that when an advance bank guarantee is taken, it's a kind of a revolving guarantee. We never see it back unless the project is completely closed and we come out of the kind of a site, including that of the O&M. So it's a matter of a nomenclature that whatever the circular reads about it, I can take away my advance bank guarantee, but that doesn't happen. Only with the closure of the project it happens. O&M is an integral part of this ABG. And usually the contractors would extend the same kind of a ABG for the same amount or a reduced amount or an enhanced amount. And that has got a kind of a characteristic of a revolving guarantee, which continues till the end of the project. So O&M can be included in the kind of an ABG which you have given in the first leg.
Thank you so much, Mr. Badrinath. Mr. Samrat, we will now take the last two questions live, and then you can conclude the webinar.
Okay. Sure, please.
Mr. Manoj Jain, please ask your question live. Mr. Manoj Jain, please ask your question live.
Hello.
Yes, please go ahead, sir.
Yeah. Thankful. I'm really thankful for this wonderful session. My question is that when the contractors are required to notify the FMC clause at the beginning and as well as the end of the FMC. Now the construction activity is being allowed by the government in the third lockdown. Now the construction is going on naturally. No doubt it is on slow progress because of the lot of issues which you have already discussed and which have you already, the same have you already apprised. This is a short of contractor workers and destruction of the supplies. But it is the, and COVID-19 is going on. And it will not happen if lockdown is complete, if lockdown is free, then COVID-19 will not be it will be closed. Then what is the procedure? Whether this FMC clause, force majeure clause, will be treated as a, and it will be notified again to the contract to the employer. Whether it is, it shall be, whether, my question is, shall it be treated as an end of the force majeure clause or not? If the contractors are allowed to to carry on the construction activities. Because this is a cascading effect is that the construction will be suffered due to this slow progress and non-performance of due to the shorts of supplies and other issues. But whether this FMC clause is going it will be treated as a continue or not?
Mr. Mitra, can you take on this question?
Well, I think the question is that whether force majeure clause will continue during the entire contract. If that is the query, yes, force majeure clause, if it's in the contract, it will continue throughout the contract. Now, if the force majeure clause covers the situation, the particular event, say a pandemic, then as Mr. Gupta has said, Energy Watchdog case also says so, that if it covers the situation, then that will prevail over the general law of frustration. Of course, this how far Section 56 will still override that is to be seen, but there are certain paragraphs in Energy Watchdog. But the force majeure clause will then continue till the very duration, till the entire duration of the contract. If there is some more force majeure events happening, it will cover that situation. I think I couldn't follow your question fully. If this is what your question was, this is the answer.
Samrat, can I supplement what Abhrajit sir has said?
Yes.
I think he has put a very valid question in the sense that, sir, what he is trying to say is that if since lockdown 1, 2, 3 have already happened and I have already invoked my force majeure clause, and should I to continue with the lockdown 4, which is a part activity, which may be zero activity, which may be 10% activity, is it continuing or not? My answer to you for this question is that force majeure stands on its own, at the same time with its own set of conditions. It's not that you have just notified and then left it to the kind of the principal to really settle about it. You need to demonstrate to what extent force majeure under lockdown 1, 2, 3, and now coming into the 4th, where you are partly operational, maybe about 20%, maybe 50% of the capacity. All that you need to demonstrate to ensure that whatever advantages of the FM clause is there, they are really brought to the table as such. To a specific question, whether you have to give a fresh notice. Imagine for a moment, the 4th is progressing again, 5th comes down, where it will be completely shut. Let's say, for example, there will be 5 which comes in, where the activity is going to be 0. If that is the case, whatever the continuing clause is there, notice is there, you need to supplement that notice from lockdown 1, 2, 3, 4 to that of 5. It need to continue with the same kind of a thread you need to draw all through. Then it will sustain and you will have your financial advantages.
Thank you, Mr. Badrinath. Mr. Rajesh Shah. Mr. Rajesh Shah, please ask your question live. Mr. Rajesh Shah, would you like to ask your question? Otherwise, we'll move on to the next question.
Mr. Shah is there.
Mr. Sourav Bank. Mr. Sourav Bank, please ask your question live.
Hi, thank you. My question is to Mr. Badrinath. I, as a developer, we have given a contract to a contractor for a time limit of 18 months to complete a residential project. The contractor in turn has rented few equipments, which is on per month basis. And obviously the contractor is not charging us for the equipment separately, because he in turn has done a rate contract with us. Now, with an extension of say 3 months or 6 months of the construction timeline, is he entitled to ask for additional payment for the equipments, say 6 months rental for those equipments? Because he in turn would be giving the rentals to the original, OEMs.
So basically, your question is that to Mr. Badrinath is.
I got it. I got it. It's an excellent question. What you're trying to say is that point number one is that whether your contract with the so-called contractor has got the force majeure built into it. Point number one. I presume that yes, it is there. Point number two is that has it demonstrated how much he is paying for the rentals of the equipment which he has brought out of the site, which is not charging you separately, but it is a part of the built-up contract value. I presume that yes, that is something which is demonstrated based on which the contract is drawn out. Now, point number three, he is fully entitled to claim for the force majeure invocation and the extension of increased cost of working, which not only includes the equipment, but maybe some site equipment, site maintenance, which is there on the site, etc., which he in turn has to pay to somebody else. All those things will be computed and will be sent to you for your adjudication. It all depends on the fine print as to how much you have to pay based on the contract value, etc. But yes, the short answer is that he is entitled to get for this extension.
Thank you, sir. The last question for the evening.
I just want to add on one thing.
Yes, please go ahead, Mr. Singh.
There's a strange British case which comes to, I'll remember it in a minute. There was a blocked road leading to a building which was still usable. The building was usable, but in practical terms, you couldn't get to the building and the lease was treated as still subsisting. Now, of course, that case and the energy watchdog case, which has been cited repeatedly, is the 2017 Supreme Court judgment here, will not match the exact facts of your situation. But you have to understand what's going to happen is these principles will apply. When it comes to a rental, the courts have repeatedly held if the property that is given out, whether it's movable or immovable property, is still with the possessor, is in your possession, and the control of the property is with the person using it, then those principles will apply regardless of the force majeure. The rent liability continues. It doesn't drop. And the second thing is, the only time that can be dropped is when the force majeure clause directly covers it. So if the force majeure clause is drafted by some genius to cover a pandemic to protect you from the rent, then there's a chance that you don't have to pay. And that may be wide enough actually in some terms, because the rent may be incidental, because you're talking about machine parts or whatever they are. But you have to look at the force majeure clause for saving, not to look for general law to protect you in that.
Thank you, Mr. Singh. The last question for the day, gentlemen. Mr. Rakesh Kapoor, please ask your question live.
My only question was that in most of the government contracts, it is written force majeure clauses that without any cost to either party. So once that is there, then question of escalations and all this is not there. Probably only extension of time is the one which becomes valid. Thank you, sir.
So, I mean, what is it you're trying to say?
No, what I'm saying is we were talking of extra costs, etc. Because of force majeure, but the clause says without any cost to either party. So once that is there in the force majeure clause, that means nothing extra becomes payable.
Okay.
Only extension of time. Yes.
Your liquidated damages is a clear win-win. Otherwise, you are subject to liquidated damages. That's a clear. It's a good profit at the end of the day. LD is something which you can really retrieve, and that's where you're going to gain a lot.
No, that's true, of course, because there cannot be any LD during this period, because that is how force majeure is there, that extension of time for any type of hindrance. This is also one of the hindrances. For any type of hindrances, there will be extension. And in this case also, once it is impossible to work, extension will be there. And because of that, maybe in some of the cases, escalation will be payable extra if there is an escalation clause. If until and unless it is a fixed item contract, fixed rate contract, escalation will also be paid. Extension of time will also be given. Liquidity damages will not be given. But otherwise, no other cause that rent is more or the rates have gone up or those type of things may not be possible.
Yeah, Mr. Badrinath, you can go ahead, I suppose.
No, I think, I think I heard him. But the point is that in these contracts, they're very typical in the sense that once, I feel that once the kind of a time extension is given, there are many advantages one would really get it under the force majeure. Otherwise, it's going to be colossal loss.
Mr. Samrat, we have a very earnest request coming in for the last question. Mr. Jayesh Thakkar, please ask your question live.
Please.
Yeah, good evening, everyone. My question is, if a lease has expired during the lockdown and the renewal is not going to happen, I would like to vacate actually, but can't hand over because of the lockdown. So what would be my status? Would I be liable to pay penalty for handing over the possession?
Jaideep sir, can you take on this question?
If you are unable to hand over possession because of the fact of the lockdown, you might be able to get away without paying rent because you didn't intend to be there. But provided you give a letter saying that, please, I don't wish to remain, I am surrendering my possession, but I'm unable to remove my possessions which are here because of the fact that I can't do it.
So there has to be a surrender of the lease.
There has to be a surrender of the lease. The fact that you are occupying the premises means that, you know, some compensation is called for. But I guess the terms of the lease might be in your favor.
I'd like to add to that, if I may. The case I was talking about, national carriers versus Panalpina, is the closest that comes to this situation, but that lease was continuing. In your case, your lease would have provision for holding over, and the Transfer of Property Act also assumes that you are holding over till the date that you actually hand over possession. So if you didn't give the keys and you weren't able to take your things out, whether it's you're temporarily prevented by COVID or otherwise, I think you'd still have to pay the rent. And the solution to that, I think, is very simple. I think you should meet your landlord and fairly arrive at a 50% arrangement and close it and don't go to court. That's
brilliant.
And negotiations are the keys.
Thank you so much, Mr. Singh. Samrat sir, we have a lot of other questions coming in, but I'm sorry, we can't take any more questions. We will have to conclude the webinar now.
Yes.
I am unable to get any further extension beyond 10 more minutes.
Just a small
question,
webinar, small question from my side to Jaideep sir or Abhrajit sir. Anyone can answer that. Sir, 56 renders the contracts void, we all know. So is it time to, I know it's up to legislation to make any changes, but is it time to import the concept of partial frustration as we have in English law, or the temporary impossibility as we have in American law? Is it time?
I don't think COVID should lead to very major changes in the law like that, because it is after all a temporary situation as far as we know so far. But that would require completely different reasons and circumstances for such legislative changes to be made.
So not COVID till now.
Not COVID. No.
Not COVID. So thank you everyone, the eminent panelists, all the attendees. So we would like to conclude this webinar. Thank you all.
Thank you.
Thank you everyone.
Thank you everybody. Thank you so much.
Sethi Saab, thank you.
Thank you.
Jaideep and Abhrajit ji. Jalan and Counsel. Thank you.
Thank you all. Thank you, Mr. Sengupta. Thank you, Jaideep, Mr. Badrinath. As always, a pleasure. Thank you, Mr. Mitra. It was a pleasure to hear you. Thank you.
Thank you.
Thank you.